Well, the no refusal basically is when someone stopped and there's reasonable grounds or reasonable suspicion to believe that that person is impaired, either by drugs or by alcohol, and that person is given an opportunity to submit to a blood or a breath test or whatever the situation dictates at the time. They're offered that test or tests to determine either the alcohol or drug content. If they refuse under the new state law, and the officer has enough probable cause to believe that that person is impaired beyond the legal limits, they can ascertain a search warrant signed by a judge, and then that blood can be taken from them as and preserved as evidence. Really, officer preference. The officer has the ability to decide whether he or she wants to administer a breath test or a blood test, and then it's just simply either situational. Each case is going to be a little bit different. You stop somebody and there's bottles in the car, there's beer cans in the car, and you have the breathalyzer available. A lot of officers and troopers and deputies choose to go ahead and get that breathalyzer. If you don't have that, but you get different other characteristics that go with the stop, and that officer may choose to do a blood test, and that way everything in that blood is preserved. Personally, I over my career have not had that many people that's refused. You explain the consequences of refusal. A lot of times people say, well, it's really not worth it, and it's really not to go through the refusal process because if a search warrant is taken and it is signed, they're going to take your blood anyway.